Welcome to the Real Free News audio podcast. Today, a comprehensive analysis explores the U.S. immigration system's constitutional foundations, statutory frameworks under the 1952 Act, executive enforcement roles, numerical limits on legal categories, judicial oversight, and recent strategies to enhance border security, interior removals, and court processing for balanced governance. The governance of immigration in the United States represents a complex interplay of constitutional principles, statutory frameworks, and institutional responsibilities that shape national policy and practice. At its core, immigration authority resides exclusively with the federal government, drawing from constitutional provisions that allocate powers over naturalization, commerce with foreign nations, and foreign affairs. This federal supremacy ensures that states lack independent control over immigration matters, though they may assist in enforcement under specific agreements. The foundational statute guiding this domain is the Immigration and Nationality Act of 1952, which has endured as the primary legal structure despite numerous amendments, establishing categories for entry, numerical constraints, and mechanisms for enforcement. This act, often referred to in its amended form, underscores a system designed to regulate both legal admissions and the removal of unauthorized individuals, reflecting evolving priorities in border security and humanitarian considerations. Within this framework, the executive branch, led by the President, holds significant discretion in implementing and enforcing immigration laws, including setting priorities for deportations and utilizing tools like parole or entry suspensions. The President's role extends to appointing key officials and directing agencies, such as the Department of Homeland Security, which oversees operational aspects through subunits like Customs and Border Protection for border management and Immigration and Customs Enforcement for interior operations. Meanwhile, Congress maintains plenary power to establish the legal parameters, including annual caps on various immigrant categories, while the judiciary provides oversight to ensure constitutional compliance, particularly in matters of due process. This tripartite structure balances authority, with the President bearing primary accountability for practical outcomes, as public perception often attributes immigration successes or failures to the executive's decisions during their term. Recent developments highlight how this system adapts to contemporary challenges, with enhanced enforcement measures reducing unauthorized entries and increasing removals. Policies under the current administration emphasize stricter border controls and interior actions, leading to record-low border encounters and surging deportations. These efforts, combined with interagency coordination and local partnerships, illustrate the system's capacity for escalation when aligned with enforcement objectives. As immigration policy continues to evolve, the interplay between statutory limits, executive discretion, and judicial checks remains central, ensuring that while legal pathways persist up to congressional maxima, unauthorized presence faces heightened scrutiny and resolution through administrative and legal channels. Constitutional and statutory foundations. The United States Constitution establishes the federal government's exclusive domain over immigration, deriving from clauses empowering Congress to regulate naturalization and commerce with foreign nations, alongside the executive's role in executing laws faithfully. This plenary authority precludes states from independent regulation, though they may cooperate in enforcement. The Supremacy Clause reinforces this federal preeminence, ensuring uniformity in immigration matters. Over time, this constitutional basis has been interpreted to grant broad deference to the political branches, with the judiciary affirming federal sovereignty in landmark decisions that limit state interventions. The Immigration and Nationality Act of 1952 serves as the cornerstone statute, consolidating prior laws into a comprehensive code that governs visa categories, deportation grounds, and naturalization processes. Originally enacting a national origins quota system, the Act has undergone significant transformations through amendments, eliminating discriminatory elements and introducing preference-based allocations. Key revisions in 1965 abolished quotas favoring certain regions, shifting toward family reunification and employment needs, while subsequent changes in 1986, 1990, and 1996 enhanced enforcement tools, including employer sanctions, increased visa numbers, and expedited removal procedures. These amendments reflect shifting policy emphases, from liberalization to heightened security, without replacing the core 1952 framework. As a permanent statute, the Act requires no annual renewal, persisting unless repealed or further modified. Its provisions dictate maximum numerical limits for most legal categories, such as 226,000 for family-sponsored preferences and 140,000 for employment-based, with no mandatory minima except in specific formulas. Refugees represent an exception, where the president sets an annual ceiling after congressional consultation, recently at a low of 7,500 for fiscal year 2026. This statutory evolution underscores a system that admits immigrants up to caps based on eligibility, irrespective of broader economic or societal demands, while empowering enforcement against unauthorized entries. Hierarchical structure of immigration control. Immigration control in the United States follows a clear hierarchy, with Congress at the apex, establishing the legal framework through statutes like the Immigration and Nationality Act. This legislative body sets categories and maximum limits, controlling funding to constrain or enable executive actions. For instance, family-sponsored visas are capped at 226,000 annually, while immediate relatives of citizens remain unlimited, reflecting congressional priorities in reunification. Through amendments, Congress has refined this structure, introducing diversity visas at around 55,000 and employment-based allocations, ensuring a balanced yet rigid intake system. The president occupies the next tier, bearing ultimate responsibility for enforcement and implementation during their term. With broad discretion, the executive directs priorities, such as focusing deportations on criminals or utilizing parole for humanitarian entries, and appoints officials like the Secretary of Homeland Security. Agencies under this branch, including U.S. Citizenship and Immigration Services for benefits processing, Customs and Border Protection for border security, and Immigration and Customs Enforcement for interior removals, execute daily operations. Recent expansions have integrated these entities more closely, enhancing deportation capabilities through resource reallocations and policy directives. At the operational level, the judiciary interprets laws and ensures due process, with immigration courts under the Department of Justice handling removal cases. These administrative tribunals, presided over by judges appointed by the Attorney General, adjudicate deportations, asylum claims, and related matters. Federal courts provide further review, often affirming executive actions but blocking overreaches. This hierarchy emphasizes shared powers, with the president accountable for outcomes, while congressional statutes and judicial oversight prevent unilateral excess. Numerical limits and immigrant categories. Legal immigration operates under congressional maxima, with no requirements for minimum admissions in most categories, allowing actual numbers to fall below caps due to processing or policy constraints. Family-sponsored preferences are limited to 226,000 annually, employment-based to at least 140,000, and diversity visas to approximately 52,000 after adjustments. Immediate relatives face no restrictions, facilitating uncapped reunifications. Temporary visas, such as H-1B for specialty occupations at 85,000, also feature caps in select subcategories, while others like student or tourist visas remain unlimited. Refugees and asylum seekers follow distinct rules, with the president determining the refugee ceiling, set at 7,500 for 2026, prioritizing specific groups, while asylum has no numerical bound, granted based on persecution claims. Other programs, like temporary protected status, depend on executive designations for unsafe countries. These limits reset yearly under the Act's formulas, processing qualified applicants up to ceilings without regard for necessity, leading to backlogs in oversubscribed areas. Unauthorized immigration, by contrast, has no allowances. All such presence is prohibited, with enforcement targeting prevention and removal. The system's design admits legal entrants up to maxima automatically, but executive tools can reduce flows below caps through restrictions or delays, indirectly influencing overall migration patterns without altering statutory bounds. Enforcement mechanisms and deportation processes. Border enforcement has intensified, with Customs and Border Protection achieving near-total control, reducing encounters dramatically through turnbacks and restrictions. Interior efforts via immigration and customs enforcement involve arrests, detentions, and referrals to courts, with deportations surging to hundreds of thousands annually. Local cooperation through expanded agreements deputizes state and county forces, creating a nationwide network despite varying sanctuary policies. Deportation begins with apprehension and a notice to appear, leading to master calendar and merits hearings before immigration judges. These judges, civil servants appointed by the Attorney General, decide on removal or relief, with appeals possible to the Board of Immigration Appeals and limited federal review. Expedited removal bypasses full hearings for recent entrants, accelerating outcomes in straightforward cases. Post-order, removals occur within 90 days ideally, involving travel documents and transport. Voluntary departure or self-deportation incentives, including cash bonuses, encourage exits to avoid harsher penalties. This process, while providing due process, creates bottlenecks from backlogs, addressed through judge expansions and streamlined adjudications. Judicial expansion and strategic implications. Immigration courts in the United States currently comprise approximately 73 dedicated facilities, staffed by between 550 and 685 immigration judges who adjudicate removal proceedings, asylum applications, and related matters. These courts operate under the Executive Office for Immigration Review within the Department of Justice, and importantly, there exists no statutory cap on the number of permanent judges until November 2028. This temporary absence of limitation creates a significant window for substantial expansion in judicial capacity, allowing the system to address the persistent backlog of cases that has long constrained deportation volumes. The Attorney General exercises broad appointment authority over these judges, who are civil service employees rather than lifetime appointees, enabling the selection of individuals aligned with enforcement priorities. Recent administrative actions have included the termination of judges perceived as lenient and the recruitment of temporary judges, including military lawyers with limited prior immigration experience, resulting in noticeably higher rates of removal orders and correspondingly lower asylum grant percentages, all while adhering to constitutional due process requirements. The process of expanding the immigration court system primarily involves increasing the number of judges and establishing additional hearing locations, supported by substantial funding allocated through recent comprehensive legislation that directs billions toward immigration enforcement, including specific resources for the Executive Office for Immigration Review. This financial backing facilitates not only permanent hires, but also the rapid deployment of temporary judicial personnel, thereby scaling the system's ability to process cases more efficiently. Such growth integrates seamlessly with broader agency reorientations, particularly the shift within U.S. citizenship and immigration services toward enhanced fraud detection, investigative activities, and direct referrals to enforcement units, which in turn generate additional removal cases for judicial resolution. Interagency coordination further strengthens operational effectiveness by improving data sharing and tracking mechanisms, ensuring that individuals subject to removal are more readily identified and directed into the court pipeline for adjudication. This strategic expansion of judicial capacity produces a powerful deterrent effect across migrant communities, as heightened enforcement visibility and accelerated proceedings encourage voluntary self-deportation among those seeking to preserve personal assets, avoid prolonged detention, or mitigate family disruptions. By enabling swifter hearings and more consistent removal outcomes, the augmented court system reinforces the overall integrity of immigration enforcement without compromising procedural fairness guaranteed under the Fifth Amendment. Ultimately, this approach aligns judicial operations with executive policy objectives, transforming the courts from a historical bottleneck into a proactive instrument for resolving unauthorized presence, thereby amplifying the impact of border security measures and interior enforcement initiatives on national immigration control. Conclusion: Reflections on sovereignty, enforcement, and systemic adaptation in contemporary U.S. immigration governance. The United States immigration system, deeply embedded in constitutional federalism and refined through statutory evolution, exhibits remarkable resilience in responding to contemporary challenges. Rooted in the exclusive federal authority affirmed by the Constitution and operationalized through the enduring Immigration and Nationality Act of 1952 and its amendments, the framework balances legislative intent with executive implementation. Recent administrative priorities have markedly transformed enforcement practices, achieving substantial reductions in unauthorized border entries and elevating deportation volumes through coordinated interagency operations. This shift illustrates the system's capacity to adapt stringent controls while navigating humanitarian considerations and legal constraints, reinforcing national sovereignty in migration management. Interior enforcement has expanded significantly, with heightened arrests, expanded detention capacities, and nationwide networks incorporating local law enforcement partnerships. These developments, supported by policy directives terminating prior lenient programs and imposing entry restrictions from numerous countries, have curtailed inflows and accelerated removals. The visible intensification of operations, including fraud detection across benefit categories and referrals for revocation, contributes to a comprehensive deterrent effect. Voluntary and incentivized departures further amplify outcomes, allowing individuals to preserve assets and avoid prolonged proceedings, thereby extending enforcement impact beyond direct apprehensions. Judicial mechanisms within the immigration court system represent a critical nexus for scaling deportations while adhering to due process obligations. With no statutory cap on judges until late 2028, the current window permits substantial expansion through Attorney General appointments, including temporary positions filled by personnel aligned with enforcement objectives. Such growth alleviates persistent backlogs exceeding 3 million cases, enabling expedited hearings and higher removal rates without reliance on broader emergency declarations. Streamlined procedures, combined with agency redirects toward investigative and removal support, position the courts as an efficient conduit for resolving violations swiftly and consistently. Ultimately, this multifaceted governance model upholds a commitment to controlled legal admissions under congressionally defined maxima while confronting unauthorized presence with resolute measures. The interplay among branches, congressional framework setting, executive prioritization, and judicial adjudication ensures adaptability amid dynamic global migration pressures. As enforcement capacity continues to strengthen through resource investments and procedural refinements, the system safeguards national interests, demonstrating that sustained, lawful intensification can achieve significant migration control without compromising foundational principles of fairness and sovereignty. Thank you for listening to the Real Free News podcast. Be sure to like, share, subscribe, and tell us what you think in the comments section. Visit realfreenews.com for more Real Free News, and check out the Real Free News store for real free food and gear. Tune in again, and until then, remember to keep it real. Free news. See you next time.